Hi there, H2B Visa School channel subscribers. Thanks so much for switching over from the old channel. I'm glad to see you back. So I have a big video today, and you're going to get two videos this week because it's December 17th, 2024, and USCIS just published what might be the biggest rule update in H2B program history, or at least in the past 15 years. So what I'm going to do is I'm going to actually address that rules update in a separate video because I have a feeling it's going to be a needed resource for employers in this coming year, but I will briefly address it in this video. Okay, so what am I talking about today? This is the episode where I'm going to review the past year of H2B changes and sort of preview the year ahead. Now, the USCIS, again, publishing this new rule change today, December 17th, sort of torpedoed a lot of my preview of 2025 content. So I'm going to try to briefly address that rule, and we'll probably have a shorter preview 2025 section than I otherwise would have, okay? So let's talk about the biggest changes in the H2B program in this just past 2023-2024 fiscal year. That was the October 1st, 2023 cycle, April 1st, 2024 cycle, and then even what we saw in this October 1st, 2024 to April 2025 fiscal year cycle. Okay, there's been a lot of big changes, so I'm going to go with three of them as the big ones. Okay, the first big change has to do with registration numbers. In the April 2024 cycle, we really got to see registration numbers in action for the first time. As you may recall, in the April 2023 cycle, employers for the first time were given something called a registration number. And what a registration number told employers who were in the peak load, seasonal, or intermittent categories is that they now had a sort of pre-approved need for workers and that they would not have to work to show or prove that need in future applications. Now, in a case at the appeal court level called Padilla Construction, the Department of Labor was essentially given the following mandate. If a need from year 1 to year 2 changes by more than if there's 10 or less workers, if it changes by more than 50% in terms of the number of workers requested, or if it's 10 or more workers and it changes more than 20%, or if the work site changes, or if the nature of the need changes substantially, then a registration number can be revoked and essentially the employer has to prove their need again. But it also had this really curious thing where it said, if the Department of Labor feels that there's anything in the application file that doesn't comport with a continued approval, then a registration number can be revoked. But that was sort of like tucked in the case. And then the final bit that Padilla stood for is the very simple, straightforward idea that once a registration number is revoked, it cannot be appealed, which is really kind of a weird thing, right? It's like we're giving you this power that can't be challenged. Okay? So the good news from the past, from the use of registration numbers. So, this year, employers put in a registration number where their statement of need once was. They didn't have to explain what their need was because they'd already proven it, is that for most applicants, it worked. It worked splendidly. It wasn't questioned, and this held true for all the seasonal applicants I had. I don't know about intermittent. I've never actually filed an intermittent application, but for peak load, we had a bump. We had a bump in the road, and here's what the setup is and then what the punchline is, okay? So this is in the public record, so I can say it. I had a client, Chapel Welding. They filed for an H2B certification for temporary welders for a contract in the southern United States, and they had a previously approved registration number for that same work site, and we didn't increase the worker count by more than 20%. We didn't change the nature of the work. We even had new contracts. But the Department of Labor retroactively deactivated the registration because they said, well, it shouldn't have been granted. Approval shouldn't have been granted the year before. So it wasn't anything about the current application that was an issue because, again, we used the registration number. But they went back and looked at the previous approval and said, boy, this shouldn't have been granted. Well, we pushed back. We argued that the retroactive violation violated fairness principles, something called the poisonous tree doctrine, which is part of the case law at the Board of Alien Label Certification Appeals, and it went beyond this withdrawal, what the Padilla Construction case judgment allows. So My biggest argument, though, is that this poisonous tree doctrine, that I made that the central argument of our appeal, stands for the fact that at that time when it was issued, the court said, look, a certifying officer can't go back into a previous case that wasn't filed, that's not before the officer, take something out of that case about the employer that is bad for the employer, and then deny the new application on the basis of that improperly found evidence, because that's a poisonous, that's the fruit of the poisonous tree. You've gone back to something unrelated to the application before you, and instead of looking at the application on the merits, you're denying it on based on something that's in the past. And that seems fair. Why should an employer be punished based on something that they did in the past? The court in our case disagreed. Essentially, it ruled that under the Padilla Construction case, the Department of Labor can retroactively deactivate a registration number, and it affirmed that the deactivation is final and unappealable even if this poisonous tree doctrine is violated. And it did this really interesting thing where the judge said, interesting in quotes, where the judge said that our client's prior submission led to the issue, not evidence improperly obtained by the DOL. But you see, the DOL could only obtain that evidence by improperly getting it from the prior case. So the judge essentially sidestepped this issue, kind of did a judo move, and I don't think got at the core of it. So the question is, do we appeal? And it's important enough where I might just appeal it to the Fifth Circuit, since this particular client is in Texas. All right. So what was the immediate takeaway from this case, which actually is now case law? What's the immediate takeaway on registration numbers? Essentially, employers seeking H2B labor certification under peak load, okay, need proof that their needs are temporary under both past and current applications. And in a way, this has strengthened the hand of the Department of Labor. In addition, this ruling is significant for the program in the long run because I think it reinforces and strengthens the Department of Labor's authority to challenge H2B registrations, even retroactively. Excuse me. It strengthens their ability to challenge H2B registrations retroactively. And so it sets a higher bar, in a way, for proving temporary need, because now you not only have to worry about the fact, turns out, because of the DOL's powers under Padilla, which they said are pretty broad, turns out you're not actually just worrying about temporary need once, you do have to continue to worry about it. That to me seems to cut against the entire point of Padilla. But what do I know? I'm not a judge. I'm just a lawyer working on the H2B program. I think it also just raises concerns for businesses that rely on H2B workers generally, although some of those, I'll pause here, I won't read what I said here, might have been addressed by this new rule change, which we're going to get to. Okay, practical advice for employers going into the April 2025 cycle with registration numbers, particularly those with peak load certifications, is to include evidence of continued need in the registration number applications. Now, if you're one of my clients and you're watching this, then you'll note that if you have a peak load, I did already ask you to upload things, to update things like contracts, and it was for this reason, because this case was pending, so I knew that this could be an outcome, and so I've already prepared you for that. For seasonal employer applications, I've also asked you for evidence. This is also why. I don't think I need it necessarily for seasonal applications, but I'm not going to take any chances, right? That's kind of my job. Okay, so that's that. Good, bad news on registrations. Most of them held up, but the DOL has somehow squeezed new powers, wider powers under a registration number that I think was designed to limit them. So never underestimate the ability of an organization to assert its dominance when its dominance is questioned. Okay, that's kind of a lesson there. Okay, so what's the second big thing? The second big thing that became apparent in this year is that premium processing is the new regular processing. Okay, and we also, incidentally, the cost of regular processing and premium processing went up. Starting in March, the fees for USCIS applications went way up in the case of H2B. And we have this sort of two-tiered, where for named, two-tier system of prices for named workers and unnamed workers, which I've talked about in other videos. I won't go through it here, but in general, the prices are higher for both small employers and big employers. They're much higher for big employers now. And the premium processing cost went up to $1,685 per petition, and we can now only put 25 workers on a petition. So if you've got 25 times 4, let's say you've got 100 workers, you're going to be paying 4 times $1,685 to premium process, because again, the big thing this year, the number 2 big thing, is that premium processing is new regular processing. Why? This has to do with 2 other developments which are related, which are also big, but they're big because they're leading to these processing quirks, these processing costs. One of those related developments is that the Texas Service Center took over processing of all H2B applications in March 2024. For those of you who watch videos earlier in the year or just follow the program, you'll know that some of the startup problems were bad enough when the Texas Service Center opened that they were sending their applications to the California and Vermont Service Centers, who previously handled H2B, one for the East Coast, generally speaking, one for the West Coast, generally speaking. The Texas Service Center, however, no longer does that, because at the end of the summer, the California Service Center let go all 400 of its immigration officers and workers. I'm sure they transferred some of them to Texas, and they closed that facility. Not to be outdone by itself, the USCIS then closed the Vermont Service Center, fired most Vermont Service Center staff in November, so now everything is in Texas. What's the upshot? The upshot is that applications that our office filed in September under regular processing for H2B, which are corner cases where that would have made sense in previous years, we were just caught unawares. This year, on regular processing, are still pending since the very start of September. So Texas Service Center has kind of put those on the back burner, and predictably, I think, seems overmatched and understaffed. And as we'll talk about in a short bit, when I look forward to 2025, I do not expect H2B approval times to go down. And I expect that if you want any sort of timely action on your H2Bs, and this has been true mostly for years, but it's especially true now because what used to take 45 days on regular processing is now apparently taking more than 2.5 months. You're going to have to pay for the premium processing. So you just got to tack that $1,685 cost on for every petition you intend on filing. Even the transfer petitions, although again, that might be mitigated by this rule, which I'll talk about a little bit here. And again, I'm going to make a big, long video. I'm going to shoot it immediately after this, addressing it. Okay, so those 2 big things. One was the registration number change. The other big thing is the premium processing is new regular processing. Okay, the final big thing is that the H2B visas in 2024 proved to be a tough sell at some consulates. Okay, all consulates in the world are not built the same, because all countries aren't viewed the same by the United States. And if we get cynical, not people from all ethnic backgrounds are not viewed identically by American officers who man those consulates. And so, notably, consulates in the Dominican Republic, in Brazil, and the Philippines, which are ones that I deal with a lot, are not ready to provide H2B applicants with a fair shake. And I think that has to do with a combination of reasons. In Brazil, if I'm looking at the analysis of attorneys who are following this, there seems to be a high degree of concern with fraud. Yeah, so in Brazil, there seems to be concern with fraud. And in the Philippines, I think they're just not ready to provide H2B visa approvals out, because they had, in 2022, there was a big hullabaloo after the Philippines rejoined the program, where the first 100 or so visas that they gave out went to a client, not a client, but well, somebody who actually became my client later after this was approved, but they went to somebody in Florida, and there was a DOL investigation, there were wage and hour division violations. And I think the consulate has a bit of a cold feet about the H2B program, which is hilarious because they just let people through on the J1 program, no problem. So we have put multiple candidates through interviews in the categories of nannies and caregivers in Brazil, DR, and the Philippines. And the DR to me is just like a no-go zone for those positions. Brazil, we are having to put multiple candidates through to try to get one approved. Brasilia seems to, there's certain consulates in the country that are worse than others. And we are just no longer going to be operating out of Manila unless somebody really, really, really wants us to. And the one place that we are finding luck with Filipino candidates are in, third-party consulates in other countries where folks are working legally. I'm starting to think that there are H2B visa subcategories not marketed as such, where the H2B visas are available to developing countries, to developed countries, but not to developing countries in certain categories. So that's a thing to keep in mind. And it seems to track that whenever there's a woman, right, of a certain age, let's say 26 to 50, who's trying to apply for one of these H2B visas, she is not being given that opportunity because she's seen as someone who is less likely to return to the country. So they're getting 214B denials, in some cases, if we're lucky, 221G processing to look into their background. But it's a shadow immigration policy of the U.S. consulates, and it's quite distinct from the USCIS and Department of Labor side of things. Okay, so as we're looking at the April 2025 cycle, which we're going to be filing for, we think like last year, January 2nd through 4th. We don't have confirmation yet. It might come down today, but there's always a 3-day filing cycle, and then a lottery is run. Here's what I think for sure is going to happen. And again, I'm going to touch down on this new rule that came out today right afterwards. Okay, so the incoming administration, that is the administration of President Trump, which we know is not as friendly to immigration overall, is going to cut down the number of H-2B visas. That seems like a pretty good shot. It might not happen, but they would cut down on the additional allotments. Now, will they cut down on the entire allotment? Well, in 2019, 2020, they did. Is there a reason to be optimistic? There is, right? So John Thune is the new head of the Senate. He is an H-2B visa champion. Donald Trump himself famously employs H-2B workers at Mar-a-Lago and perhaps other properties. And there seems to be, and always the H-2B program, I should say, has been championed by Republican members of Congress and sort of kept at arm's length by Democratic members of Congress due to union interests. So it's not doom and gloom for the H-2B, but it does seem clear that there will be fewer H-2B additional visas allotted. So treating your H-2B workers, making sure they come back, being able to recruit within the country for those with H-2B visas is going to be even more important over the next 4 years or so, and perhaps longer. Okay, the other trend, I touched on it a little bit with our second big thing, where I said premium processing is the new regular processing, but it's longer wait times at the DOL and USCIS. So even though the Trump administration may not be unfriendly towards the H-2B program, I think that what we know of their potential plans to maybe cut down the size of government, reduce funding, etc., and specifically change the priorities of immigration agencies from processing benefits to acting as vetting agencies, once again, akin to a situation we saw right after 9/11/2001, is that the wait times could get longer at both the Department of Labor and USCIS for visas, meaning even longer than they actually are. And we could see even another fee increase because USCIS, for example, is self-funded. Okay, the DOL infamously is not self-funded. Infamously, they're always underfunded in the H-2B and H-2A programs. So if their funding is cut even a little bit, well, that could mean further funding cuts for an already underfunded DOL, and their wait times could go up for that reason. Okay. And then on the consular side, we might see certain countries being completely frozen from processing non-immigrant visas, the so-called travel bans from 2017, if you recall those, and that could have an obvious impact. Okay. Lastly, I think that on the concrete side, we can expect that there'll be audit pressure on employers will likely increase. Now, that could crash against the fact that some of these agencies will be underfunded or less funded than before and have more pressure on them to do more vetting of individual applicants. So maybe it's a wash, maybe nothing changes, but it'll feel like there's more pressure. And then less concretely, I anticipate that the anxieties of foreign workers themselves will be higher, right? They'll be in this environment where immigration is on the news a greater number of nights. I think there'll generally be a lot of anticipation about what will happen with immigration enforcement, and that just means that foreign workers might be more anxious, maybe less happy than they were before, which could impact how employers have to treat these employees, okay? So let's lastly just briefly talk about that January 2024 filing date. It's coming up 2nd to 4th. It's the January 2nd through 4th, probably. We're going to get a final announcement again here from DHS shortly, I anticipate. And that's when you get your applications in for an April 1st start date. A lot of employers I saw this year move to a March 1st start date, right? A lot of, especially like landscapers, some construction companies in the Midwest. And so I think we're going to see for the second year in a row, actually, the number of April 1 applications is going to go down, which will slightly increase the odds of being in the first couple of groups. But just like last year, I think it's going to be important to be in Group A or Group B to get new workers. And it's going to continue to be actually the importance of being able to recruit returning workers, being able to be open to get workers from Central America is only going to go up. And we'll talk about more about that as we actually enter the cycle. But you should be ready. You should be getting everything prepared. Make sure that your job orders are posted on your SWA. A lot of states offer the service of you putting in the job orders now so that they can review them for completeness. But you can certainly open the job orders, get them prepped, so that all you have to do January 2nd through 4th, or whatever that final date is press send on that 9142, and that's certainly what we're trying to do. Here, I'm not interested in spending another January 2nd through 4th working, I'll tell you that much, but we'll see. We'll see what happens. Okay. So now, I want to just briefly, having said that, having talked about the prior year, having talked about the three big things and about what's happening in the future, looks like there's a fourth big thing this year. Okay, literally today, literally as I was going to shoot this, we got this new announcement from the Department of Homeland Security that they've created a new rule. Okay, a new rule that affects H2 visa programs. And just briefly, here's the key changes, and I'm going to go through these in detail in the next video, but these are major, okay? First, employers will now be able to, as of January 17th, 2025, employers will be able to hire workers regardless of nationality. So there used to be, right now there's an H2B countries list. There's always been a countries list of countries that can participate in the program. We're getting rid of that. Now, my immediate thought is like, does that mean India can participate? Because if India can participate, you're going to have Tata and every other kind of recruiting company that's on H2B start entering the lottery, and we're going to double the size of this lottery really quickly. So that's like, for some reason, the first thing that jumped into my mind. But yeah, if there's no nationality requirement, that means that countries in South Asia, which have traditionally been barred from this program, can participate. Equally significantly, countries in Africa, which Africa's mostly been shut out. The entire continent of Africa, all those countries have been mostly shut out of this program. They can now participate. This is going to, I think, change the face of this program potentially. How, I don't know. I'm not a psychic, but I know one. For those of you who know what that wink means, you know what that wink means. Okay. Okay, the other thing is that the DHS has made it easier to reset the 3-year maximum stay clock. Okay, workers just need to stay outside the U.S. for 60 days to restart the clock. Okay, but here's the other big one. If employment ends, so let's say it ends early, H2B workers now get up to 60 days to find a new job or prepare to leave the U.S. That's huge, right? That was one of the biggest worries of this program. What happens if work ends early? So there used to be a 30-day grace period after petition revocation. That also has been extended to 60. And now they are codifying the fact that H2 workers have H2 status 10 days before their petition begins and 30 days after it expires. So this puts it in line with something like the J1 program. And this is, again, going to be a very big win if it stays, which I'll talk about in a second. And then finally, the portability changes that were kind of piecemeal updated every year are being made permanent, where if somebody switches employers, as soon as that employment petition is in, they can start working with that employer. And I wonder if that's, until the application's approved, or if there's a 60-day rule there as well. It's unclear, but again, in the big video, we'll take a look at it. All in all, This could, if just that was happening, you know, and we got to keep the H2B program allocations of additional workers like we've had under the Biden administration, I think it would be all rosy and sunny for this program going forward. But there's some stuff in there where I'm already thinking, well, what does this mean, having a no country list? I mean, it sounds fair and equitable in theory, but it's going to bring some like really big players into the market who are already active in the H1B space. And I'm not sure what that means for employers. If you're familiar with that, we don't have to get into it, but that could be interesting. And then the other thing is that these extensions of one's stay being extended for 30 days after the visa, that's nothing but good. Okay, that makes it a lot easier for employers to think through things. So the future in 2025 is fewer visas but more flexibilities for workers, right, would be the summary. And it means that you will have to continue to kind of develop your workers, your stable of temporary workers who already have H2B status, who are in the US, are able to return. Okay, that's going to continue to be critical. So I hope that that's helpful. Okay, I'm going to try to summarize that in the description of the video here. But we're also doing is, you know, we will take the transcript of this and post it on fronteralabor.com. That's our new site. So it's fronteralabor.com. And I really appreciate you guys watching. Please share, subscribe if you haven't. But we love it if you share this stuff. LinkedIn's high impact for us. Facebook's high impact for us, even though we're not on Facebook. And just sending it to people via email. Okay, we are striving to give you the best H2B update. So thanks so much and have a great day.